All right, good morning, everybody. I'd like to call to order the 151st public meeting of the Massachusetts Gaming Commission. We're here at the Boston Convention and Exhibition Center for today's agenda. Chairman Crosby is not with us today. He's on a well-deserved vacation, and so the four of us will proceed in his absence. We usually begin with the minutes, which frequently is the highlight of the meeting, but this time today we're going to skip those, and we'll save those until all five of us are present at the next meeting, and proceed directly to the main order of business, which is the report from the Investigation and Enforcement Bureau with respect to mass gaming and entertainment. Before we actually get to the content of that, I'd like to set the stage a little bit to recall and inform how we got here. Mass Gaming and Entertainment is an entity that's pursuing a Category 1 or casino gaming license. This hearing is being convened in accordance with 205 CMR 115.04 paragraph 3. That's available for all to see, but governs hearings like this. The entire commission will collectively preside over this hearing and over whatever decision will follow when it concludes. I'd like to explain the process, though, that led us to this point, as well as the process that will follow here today. On July 11, 2013, almost 2 years ago, the commission held a similar hearing regarding mass gaming and entertainment, which was then applying for a Category 2 or slots parlor license. An inquiry into suitability is, as the name suggests, an inquiry into the fitness of the applicant to hold a gaming license. And that inquiry is required by the gaming statute, which also contains criteria the commission considers in making its determination. At the conclusion of the hearing 2 years ago, the commission unanimously concluded that mass gaming and entertainment was qualified and had shown that by clear and convincing evidence that its suitability. In September of 2013, however, Mass Gaming and Entertainment withdrew its application for a Category 2 license for reasons wholly unrelated to any suitability issues. During the same year, and with the same results, the Commission conducted a suitability investigation regarding Raynham Park, LLC, which was also seeking a Category 2 license, but was ultimately unsuccessful. And during the course of that investigation, the commission considered the suitability of George and Letitia Carney, who then were principals in Raynham Park LLC and now are principals of an entity called Sweeney Investments Incorporated. So with that background, Mass Gaming and Entertainment, now reconstituted as a joint venture between an entity known as Mass Gaming Holding LLC and Sweeney Investments. We'll hear more about that as the report is presented. Now that entity, Mass Gaming and Entertainment, has applied for a Category 1 or casino license, and as before, the commission must make an inquiry into Mass Gaming and Entertainment suitability to hold a license. This time, though, the suitability inquiry builds on the inquiry conducted 2 years ago, and in essence amounts to an update of that earlier inquiry. To carry out that update, the Commission's Investigation and Enforcement Bureau has conducted an investigation into mass gaming and entertainment, and the individuals, called qualifiers, you'll hear that term as we proceed, who have the power to exercise significant influence over the management or operation of mass gaming and entertainment's ongoing business. The Bureau has generated an investigative report of its findings and has submitted it to the Commission for the Commission's ultimate decision, and that's part of the packet that is before the Commissioners today. The hearing will proceed as follows. At the outset, the IEB Investigation and Enforcement Bureau Deputy Director Loretta Lilios will provide an overview of the investigative report relative to the suitability of Mass Gaming and Entertainment's Phase 1 application. Any commissioner may ask a question of Director Lilios at any point during her presentation. Director Lilios may be joined by others who participated in the investigation that led to the report, or she may not. They will also be, she will also be available to answer any questions or offer clarification. The commission will then discuss the matter and take a vote after after Mass Gaming and Entertainment is given any opportunity it would like to use in order to respond to any part of the content of the report. As was the case in 2013, the burden is on Mass Gaming and Entertainment to demonstrate by clear and convincing evidence both its affirmative qualification for licensure and the absence of any disqualification for licensure. Deputy Director Lilios is, of course, joined here today by Director Wells. And without further ado, I'll turn the matter over to you, Director Lilios.
Thank you very much, and good morning, Commissioners. Thank you for this opportunity to address you, to update the suitability of the applicant, Mass Gaming and Entertainment. As an initial matter, I want to recognize the members of the IEB team that worked on this suitability update. On the state police side, Lieutenant Kevin Condon and Trooper Dean Cerullo lent their efforts and expertise. And on the financial investigation side, Paul McGrath and Monica Chang worked extremely diligently and thoughtfully, as well as Vanessa Barone, who assisted in a particular area. In addition, Drew Chamberlain from HLT Advisory, Inc. was very helpful, and he is present this morning. And of course, I want to recognize Director Wells for her leadership. I also want to thank the applicant, who has been cooperative and engaged over the past 3 months in this suitability update process. The applicant has representatives present today. Attorney John Donnelly is here representing Mass Gaming and Entertainment. Attorney Paul Seaman, who is an advisor to the Rush Group, is also here. Attorney Michael Maurizio is present representing Mr. George Carney, and Mr. George Carney and Mrs. Letitia Carney are here as well. As Commissioner McHugh stated, the Commission previously issued a positive determination of suitability for the applicant in July of 2013 in connection with its then proposal for a slots license. The applicant ended up withdrawing that application, but the Commission allowed it and other applicants that were not awarded a Category 2 or Region A or B license to apply for a Region C license without filing a new RFA 1 application, so long as they provided information as requested by the IEB, which this applicant has done. Almost 2 years have passed since that prior determination, and the applicant has now proposed a resort casino in the community of Brockton. As suitability is an ongoing concept, the IEB has updated its investigation to assist the Commission in determining whether the applicant is suitable at this time. In the present application, there are 9 entity qualifiers and 14 individual qualifiers. 4 of the entity qualifiers and 13 of the individual qualifiers were previously deemed suitable in 2013. The previously qualified entities, including the trusts, as well as the individuals, were all subject to the full background check back in 2013. And I refer you to the minutes of the suitability hearing from July 11th, 2013, when these investigative steps were described in full. As part of the updated investigation, the IEB required qualifiers who went through the process in 2013 to submit detailed updates to their 2013 applications, including updated financial information and net worth information, updated tax information, and updated licensing data. The IEB reviewed these submissions, conducted additional criminal and database checks and verifications, had numerous telephone conferences with representatives of the applicant, and visited the site of the project. With respect to the 5 new entity qualifiers and 1 new individual qualifier, the IEB required the submission of business entity disclosure forms from the entities and multi-jurisdictional personal history forms and Massachusetts supplement forms from the new individuals, as well as additional supplemental materials and communications as determined by the investigators to be needed. All of the qualifiers were subject to criminal checks, media checks, credit checks, litigation checks, and political donation checks as well. All of this was done to assist the Commission in evaluating whether the applicant has satisfied its affirmative obligation to demonstrate its qualifications as of today, as well as the qualifications of each of the entities and individuals identified by the IEB as qualifiers by clear and convincing evidence according to the Phase 1 suitability criteria in Chapter 23K, Sections 12 and 16, and 205 CMR 115 and 117. You have a 70-page report before you outlining the IEB's findings. The redacted version has been made available to you today to consider as part of this meeting and is part of the record of this meeting and is available to the public. The redactions were made because the IEB considers a great deal of personal and confidential information that is not appropriate or indeed is not legal for public disclosure. There has been a minor comment from the applicant brought to the IEB's attention in the report, reasonably so, and staff will address that in the near future. I am aware that you have read the report, so I will give a summary overview and some of the key points. The applicant before you is Mass Gaming and Entertainment, LLC. It was established in 2011 for the purpose of pursuing a gaming license in Massachusetts, and it has no business history of significance and has no regulatory history. The applicant continues to be managed by Neil Bloom as chairman, Gregory Carlin as CEO, and Andrew Bloom as secretary and treasurer. The applicant is in compliance with all of its tax obligations in the Commonwealth. An updated criminal history search was conducted for the applicant and, in fact, for all of the qualifying entities, and in all cases, neither the entity nor its ownership nor any of the officers have a criminal record that would negatively impact suitability or subject them to disqualification, and the same holds true for the individuals. The applicant's ownership structure has changed since 2013. In 2013, the applicant was directly owned by a group of 5 trusts, all related or closely associated with members of the Bloom family from Chicago, and by also ownership interest by one qualifying individual. Today, the applicant is owned by Mass Gaming Holdings, LLC. The investigators discovered no new information in the updated investigation that negatively impacts on Mass Gaming and Entertainment's Phase 1 suitability for licensure. Mass Gaming Holdings, the parent company of the applicant, is a newly formed entity with no business history and no regulatory history. Mass Gaming Holdings is owned by 4 qualifying trusts, specifically the Carlin Dynasty Trust and 3 Bloom Family Trusts. These 3 Bloom Trusts were created in 2013 after the prior suitability finding, when the previous trusts split into 2 new separate trusts, each splitting into an exempt and non-exempt trust. These new trusts were created to protect Bloom family assets and to make assets available for the Bloom family's business endeavors. And these 3 new Bloom family trusts are the new entity trust qualifiers. I note that when the trusts severed, the trust documents did not change, the trustees remained the same, and the beneficiaries remained the same. Therefore, although the severance of the trusts resulted in 3 new trust entity qualifiers, the severance did not result in any new individual qualifiers. The 3 new trusts are the 2013 AGB Family Dynasty Trust Exempt Number 2, where the A is for Andrew Bloom, and he is the son of Neil Bloom and the grantor and trustee of that trust. The 2013 LNB Family Trust Exempt Number 2, L for Leslie, Neil Bloom's daughter, who is also the grantor and trustee of that trust, and the 2013 Meredith A. Bloom Wolf Family GST Trust Number 2, where Meredith is Neil Bloom's daughter and the grantor and trustee of that particular trust. The investigators looked into the trusts, where the money came from, and found no issues of concern with those trusts. The assets of the trust consist of bank accounts and investments in closely held or Bloom-related entities. The investments are not in publicly traded entities, but based on a review of financial documents that took into account the 2013 review, the valuation assigned to the trust's investments is not unreasonable. All 3 of the Bloom family qualifying trusts are currently undergoing a suitability investigation by the Pennsylvania Gaming Control Board for the 2 casinos that Bloom and Rush have in Pennsylvania, and by the New York State Gaming Commission for the recently licensed Bloom facility in Schenectady. Andrew Bloom, Leslie Bloom, and Meredith Bloom Wolf, the grantors and trustees of those trusts, have each been found suitable in Massachusetts, Pennsylvania, Louisiana, Illinois, and Ontario, and Andrew Bloom has also been found suitable in Mississippi. The investigation did not reveal any derogatory information that would reflect negatively on any of those three trusts' Phase 1 suitability. The Carlin Dynasty Trust also has an ownership in Mass Gaming Holdings, the parent of the applicant. The Carlin Dynasty Trust was formed by Gregory Carlin and his wife, and that trust was previously found suitable in 2013 by the Commission. Since 2013, the Carlin Dynasty Trust has been found suitable by the Illinois Gaming Board, and the trustee, Gregory Carlin, has been found suitable in Mississippi, Pennsylvania, and Illinois. The investigators discovered no new information that negatively impacts on the Carlin Dynasty Trust. None of the trusts will be involved in any operational or managerial activities relating to the gaming operation, but will be combined to an investor ownership role. As in 2013, on the operational side, it is intended that Rush Street Gaming LLC, which in turn is owned by Rush Street Gaming Partners LLC, will provide the operational and oversight functions of the casino should a license be granted. Rush Street Gaming's ownership structure has not changed since it was found suitable in 2013. As in its 2013 application, it remains a wholly owned subsidiary of Rush Street Gaming Partners. Rush Street Gaming is managed by Neil Bloom as chairman, Gregory Carlin as CEO, Andrew Bloom as secretary and treasurer, and David Patent as president and chief operating officer. At the time of Rush Street Gaming's 2013 application, it had been found suitable for licensure by the Mississippi Gaming Commission, the Illinois Gaming Board, and the Pennsylvania Gaming Control Board. At the time of the initial application, the Rush Street Gaming Partners ownership group was comprised of 3 Bloom family trusts and 1 natural person qualifier. Since the 2013 suitability finding, the ownership structure of Rush Street Gaming Partners has changed. Now, Neil Bloom and Gregory Carlin each have ownership interests in Rush Street Gaming Partners in excess of 5% each. The officers of Rush Street Gaming Partners are Neil Bloom as chair, Gregory Carlin as CEO, and Andrew Bloom as treasurer and secretary. In 2013, Rush Street Gaming Partners had been found suitable by the Illinois Gaming Board and the Pennsylvania Gaming Control Board. Currently, both Rush Street Gaming and Rush Street Gaming Partners are undergoing a suitability investigation in New York relative to the Rivers Casino and Resort at Mohawk Harbor, and they both have pending applications with the New Jersey Casino Control Commission and the Alcohol and Gaming Control Commission of Ontario. The investigation has compared Rush Street Gaming and Rush Street Gaming Partners' 2013 and 2015 business entity disclosure forms and noted no additional material changes. The investigators discovered no new derogatory information that affects either of those entities. Before moving on to the individual qualifiers, while we are talking about the Rush Street group, I would like to bring to your attention some of the regulatory violations that the IEB reviewed. As part of the investigation to update suitability, the IEB reviewed recent gaming regulatory violations that resulted in fines for the 3 U.S. casinos where the regulated entities operate in Pennsylvania and in Illinois. There were some incidents that caused the IEB's concern. In particular, there was an incident at the Sugar House Casino involving 12 slot machines registering below the 85% minimum payout percentage for a period of 6 months. There was an incident at the Rivers Casino in Pittsburgh involving count room paperwork being improperly returned. There was another incident at the Rivers Casino in Pittsburgh involving a poker dealer ignoring the red light with cards dealt twice while short 2 cards. And there were incidents of mishandling of shufflers by dealers. There were 5 incidents at the Rivers Casino in Pittsburgh involving slot technicians setting games incorrectly without approval from the regulator. And there also were fines for self-exclusion and underage incidents. In the matters that I brought to your attention, there were all fairly significant fines imposed. Moving Moving on from the violations to the individual qualifiers, Neil Bloom, Andrew Bloom, Leslie Bloom, Meredith Bloom Wolf, and Gregory Carlin all have ownership interests in the, as we discussed, in the applicant's parent company, Mass Gaming Holdings. Neil Bloom, Andrew Bloom, and Gregory Carlin also have control over the Rush Street oversight entities. Leslie Bloom and Meredith Bloom Wolf are passive investors with no managerial or oversight control. These 5 individuals all were subject to a full background investigation in 2013. Since that time, they have applied for licensure in several jurisdictions as detailed in the report. All foreign jurisdictions were contacted and reported no derogatory information relating to any of those individuals' licensure or their ongoing suitability. An income analysis and a net worth analysis were performed for each of these individuals, and there was no derogatory information uncovered with respect to their financial integrity, financial responsibility, or financial stability. The investigation also updated the suitability of 6 additional individual qualifiers with oversight control only. Those individuals are David Patent, the President and Chief Operating Officer of Rush Street Gaming, Timothy Drekoff, the CFO of Rush Street Gaming, Zaletta Wyatt, the Vice President of Strategic Planning for Rush Street Gaming, Suzanne Trout, the Chief Marketing Officer for Rush Street Gaming, Joseph Sabetta, the Vice President of Operations for Rush Street Gaming, and James Jabinski, Director of Slot Performance and Analytics for Rush Street Gaming. All of these individuals went through the full background invest in 2013, and since that time they have applied for licensure in several jurisdictions as set out in the report. Again, all of the foreign jurisdictions were contacted, and no information, negative information relating to ongoing suitability was reported. Their finances were reviewed for financial stability, responsibility, and integrity with no derogatory information and no negative findings, and no new information in the updated investigation that negatively impacts their Phase 1 suitability. Joshua Risley was determined to be a new qualifier for the applicant. In May of 2013, he was hired by Rush Street Gaming as their Vice President of Analytics. You have the IEB's full investigative report incorporated into the update report starting on page 51 relating to Mr. Risley. Immediately prior to his position at Rush Street Gaming, Mr. Risley was an FBI agent in Detroit for 4 years, a position that he voluntarily left because, as he reported, he saw the Rush Street Gaming position as a good opportunity. He has been working in the gaming industry since 2001, and he has held positions as the Director of Gaming Revenue, the Director of Slot Performance, the Consolidated Operations Analyst, and the Consolidated Operations Analyst for several Caesars property, and he also has been an income control clerk for Caesars Entertainment in Missouri. Prior to that, he has held several positions for financial institutions, including as a portfolio analyst and a stock analyst. Mr. Risley submitted all of the required forms and supplemental documents to the INB, and investigators conducted background checks where we looked at employment history, criminal record, education, political contributions, references, media coverage, directorships and shareholder interests, civil litigation, bankruptcies, and property ownerships. Investigators also conducted a financial responsibility evaluation with positive results. Mr. Risley attended St. Louis University, where he was awarded a BA in economics, and he disclosed that he has been licensed in Illinois with an active license, Pennsylvania, active license, New Jersey, expired license, and Missouri, expired license, and he has a pending license in New York. Again, all jurisdictions were contacted and no derogatory information reported. Overall, there were no significant investigative issues uncovered related to Mr. Risley. Mr. George Carney has been deemed a qualifier because he has an interest in Sweeney Investments, LLC, which in turn would have an ownership interest in the applicant should the commission issue a Category 1 license to the applicant. Mr. Carney is already licensed by the commission under Chapter 128A to conduct simulcasting at his Raynham facility. He was previously deemed suitable in 23 in connection with the Raynham Park application for a slots license. The investigation has confirmed some changes since the time of the Commission's suitability finding in 2013, specifically that Mr. Carney has resigned from his positions as General Manager, President, Treasurer, Secretary, and Director of the Brockton Agricultural Society. The Brockton Agricultural Society owns the site which the applicant proposes to build on. Ms. Letitia Carney has an ownership interest in Sweeney Investments LLC as well, which, as explained, would have an ownership interest in the applicant should a license issue. Mrs. Carney has no management role in Sweeney Investments, and neither Mrs. Carney nor Mr. George Carney is expected to have any management role in the applicant. Mrs. Carney was found suitable in 2013 as well. Mrs. Carney disclosed one investigatory proceeding regarding a liquor license suspension in the town of Raynham, resulting in a one-day suspension of liquor license at the Raynham Derby Club for serving a minor. Financial analyses of Mr. and Mrs. Carney were performed. In the Raynham Park suitability report, it was noted that George Carney reports a substantial amount of assets, but most of the overall asset value is in the form of non-liquid investments such as real estate, loans receivable, and interest in closely held businesses or trusts. Offsetting the assets are actual liabilities and a very high level of contingent liabilities representing debts of certain Carney business ventures that Mr. Carney has personally guaranteed as to payment. The updated financial investigation reveals that the structure of the most recent net worth statement for George Carney remains unchanged, in that he has low levels of liquid assets and the majority of his assets are in the form of related party receivables and investments in closely held business ventures. His liabilities are primarily in the form of related party payables, and he maintains significant contingent liabilities in some business ventures. That said, when combined with the net worth of Letitia Carney's, the Carneys have liquid assets and real estate holdings that exceed the total amount of debt owing. While there may be some requirement to sell certain assets, if liquid assets were insufficient, their financial position is considered stable. Under an agreement with the applicant, Mr. Carney has no obligation to contribute any equity to the applicant beyond the after-tax proceeds from the sale of the project site, details of which I'll address in a moment. The investigation discovered no new information in the updated investigation that negatively impacts Mr. and Mrs. Carney's Phase 1 suitability. Turning to the project site, the applicant has designated the host community of Brockton as its proposed site, and a vote is scheduled there for May 12th. The facility is to be built on Lot 7, a 45.573 acre parcel comprising most of the current Brockton Fairgrounds. Lot 7 is owned by the Brockton Agricultural Society. The Brockton Agricultural Society has an interesting history. It was formed in 1874 to promote and encourage agricultural activity for the benefit of the community. Mr. George Carney, a qualifier in this application due to his ownership in Sweeney Investments, is the majority shareholder in the society. Letitia Carney, also a qualifier, owns some shares. Mr. Carney has in the past been a general manager, director, and officer of the society at various points, but as of around November 14th, 2014, he is no longer holds any of those positions or offices for the society. In addition to holding the Brockton Fair, the society has some business ventures. The society has licensed the occasional use of the fairgrounds to vendors who conduct things like flea markets, farmers markets, rodeos, and similar special events. The society also has entered into 2 more significant leases or licensing agreements. In 2009 and again in 2013, the society entered into a lease with the city of Brockton, whereby the city leases a salt shed from the society, and the city has the right to use the surrounding area 24/7 to store roadside salt and for incidental operations, and the city has rights of renewal through October 31st, 2016 on that lease. In 2001, the society also entered into a ground lease for the placement of a cell tower on Lot 7. The society files taxes as a C corporation and pays property taxes at the commercial industrial rate. The investigators examined the society's tax returns for the years 2008 through 2012, and they appear to be in order. On January 14th of 2015, the Society, through its president and treasurer, executed a letter agreement with Mass Gaming and Entertainment. In the agreement, Mass Gaming and Entertainment has agreed to purchase Lot 7, subject to the award of the Category 1 license to the applicant. The directors of the Society have already approved this transaction. Under the letter agreement, the Society will first obtain the 2/3 affirmative vote of the shareholders to approve the sale of Lot 7. A secondary mechanism for the land to be contributed to the joint venture has not been fully developed, but will be brought before the IEB and the Commission for the necessary review and approvals in advance, should it materialize. Over the years, Mr.
Director, can
Yes.
you expound on that a little bit more, please? Or repeat that?
That there is a secondary mechanism for the land to be contributed to the joint venture that has not been fully developed, but will be brought before the IEB and the Commission for the necessary review and approvals in advance, should it materialize. So the IEB did not fully investigate or vet that possibility because it had not materialized. But it has been made clear that if that route is to be followed before that process commences, the applicant would need to come back to the IEB,
Right.
and the IEB would bring that to the Commission as necessary.
But it's not anticipated that that alternative would be materially different from, at this point, from what you just described in terms of ownership and requirement for contributions and roles.
For contributions and roles, that is
it's
true,
not,
and
okay.
nor is it anticipated that any votes of the shareholders would
Right.
not be required.
So basically, that's a different way of giving MGE control over the site that they need.
That's my understanding, correct?
Apart from an outright sale.
That's,
Okay.
it's my understanding that an outright sale would nonetheless materialize, but it just might happen differently at the society end.
Okay.
Over the years, Mr. Carney has made loans to the society. In 2001, the society executed a promissory note payable to him, which counsel for Mr. Carney stated was to enable the society to make capital improvements and repairs to the racetrack facility at the Brockton Fairgrounds. This note to Mr. Carney has been secured by a mortgage on the society's real property. The investigators requested certain of the society's records. Many documents were provided, but Attorney Maurizio reported that for some of the IEB's requests, it would be a major task to attempt to recover all documents requested. Investigators looked into Mr. Carney's purchase of a parcel of property from the society in the late 1970s at 500 Belmont Street. The investigators learned that in 1984, the Commonwealth's Tax Board issued a decision that validated the purchase price Mr. Carney paid to the society for that parcel. The tax board actually valued the land at an amount that was slightly less than the price he paid. Ultimately, the investigation uncovered no facts regarding the land transaction which necessarily negatively impacts suitability. Nonetheless, in furtherance of 23K's mandate to ensure public confidence in the integrity of the gaming licensing process, the IEB recommends that the Commission consider adding 4 conditions to a determination of the applicant's suitability. The recommended conditions of Phase 1 suitability are moving forward and until directed otherwise by the Commission. 1, all of the transactions involving the society and Mr. Carney, Mrs. Carney, any of the Carney-affiliated entities, and/or any qualifier, including but not limited to the disposition of Lot 7, are required to be documented in detail, and the society is required to provide such documentation to the IEB promptly upon its preparation. The second recommended condition is that the society's books are required to be maintained according to generally accepted accounting principles. And it is reported that that is the case presently. Condition number 3 is that the society is required to promptly update the contact information for its shareholders and to use the updated contact list to notify the shareholders of all meetings, including the notice to shareholders in advance of the vote for the sale of Lot 7. And the 4th recommended condition is that the society is required to continue to maintain all of the required filings to the Secretary of the Commonwealth, which again, it appears, the investigators have reviewed those filings, and it appears that those are currently being made.
Director, you mentioned that certain documents were requested, but would take a lot of effort to produce. Is that? But those documents were not documents that are required by law. Is that accurate?
That is true for some of the requests. For instance, minutes were requested, and minutes of one director's meeting were provided. But minutes are not required to be taken, as the society is not a governmental body subject to records retention laws or minute-taking requirements of, for instance, the open meeting law. My comment with respect to that it would be a major task to produce such records went more to the IEB's request for lease and licensing documents. And Mr. Maurizio can maybe shed a little more light on this, but it is my understanding that there are many small leases, arrangements for small vendors to come on site, and that there may be documentation that exists for those. I think a football tournament was given as a recent example where the documentation may exist but was not easily accessible. I had requested over a 20-year period. So some documentation was required for the more significant leases and licenses, but that was the response for the other matters. And that also affected the IEB's recommended conditions.
So those are historical leases and historical operating arrangements, not at least as far as you understand it, lease arrangements or other operating agreements that are currently in effect.
Well, these the cell tower lease and the salt shed lease are current.
Apart from those two, these other documents are historical.
Correct.
Right. Okay.
Can I ask a question on the conditions, or will we have on one of them?
Sure.
Were you ready to? Okay. So condition number 1, you mentioned that all the transactions of the society going forward be documented in detail and provided or made available if requested, if upon request from the IEB, prior to or soon after the transaction takes place?
The recommendation is that moving forward from today and until otherwise directed by the commission, that documentation is to be kept for the transactions involving the carnies and or the land, and affirmatively to be provided to the IEB.
After the transaction has taken place?
Upon preparation of the documentation. On an ongoing basis.
Okay.
Would be the recommended condition.
But documenting a transaction prior to actually entering into a transaction is different from just providing the documentation after the transaction has been entered into. I'm specifically asking about the timing element of this. Do you want to know in advance, or do you want to know soon after?
If, for example, there's a lease.
Yes. If there's a lease to be executed, or it has been executed, do you want to know prior to or soon thereafter?
Well, I think this is connected to the bylaws of the society. So, for instance, if the bylaws of the society say that the directors can act on a certain matter at a meeting, then I would envision that the IEB would receive advance notice of the directors' meeting. And so in that way, the IEB would have advance notice of a meeting, but would have after-the-fact notice documenting what actually happened at the meeting. Does that address your question?
Yeah, well, I want to make sure that we are not in a position where we're approving a transaction, either because it has been provided in advance and nothing has been said, let's say, implicitly or otherwise.
I
And
understand, yeah.
if that's the intent, let's, I want to understand just what transactions you might be thinking about.
And I think of particular concern is that we are notified in advance of notifications of shareholder meetings where transactions involving the lot or involving the Carneys are anticipated.
Okay.
Moving on to a description of the anticipated deal itself. Mass Gaming and Entertainment and Sweeney Investments executed a joint venture letter agreement on January 23rd of 2015, which anticipates that an LLC will be formed for a joint venture entity that will own the interest in the applicant. The terms of the joint venture agreement assumed that the project costs would amount to $605 million, of which $450 million, or 75%, would represent debt financing, and the remaining $150 million, or 25%, would be provided by the Bloom Group and Sweeney Investments, or the Carneys. The terms of this agreement are described more fully starting on page 34 of the report. The Carneys are required under the agreement to contribute all of their after-tax proceeds from the sale of the site in return for common equity in the joint venture entity. Other terms of the agreement allow but do not require the Carneys to contribute an additional capped amount. The intended organizational structure appears on page 36 of the report. The net worth of each of the owners with greater than 5%, as well as the net worth of the individuals who are the grantors and trustees for the identified trusts, were examined. This net worth is far in excess of the range of the equity capital identified. We do note that the majority of these assets are in the form of real estate or private business interests and thus are non-liquid. In order to address the issue of timely access to equity capital, the applicant has provided a letter from Bank of America that the Lamb partners have access to an amount in undrawn funds available to them in an existing credit facility that demonstrates to the satisfaction of the investigators that they have access to the required capital for the project. The Lamb Partners is an acronym that stands for Leslie, Andrew, and Meredith Bloom.
Can I ask a question
Yes.
on that? It is not envisioned that the sale, the amount of that contribution, that equity contribution, which is in the form of the land, would change between now and the closing of that, if they awarded a license, is there?
Well, the financial aspect of this proposal is based on current market conditions, and I believe that that will be looked at again at the Phase 2 stage.
Okay.
In conclusion, taking into consideration the entirety of the IEB's investigation, the IEB concludes that the applicant and each qualifier have established their Phase 1 qualifications for licensure by clear and convincing evidence, including the statutory criteria of integrity, good character, honesty, reputation, financial stability, and financial responsibility. The IEB recommends that the Commission find the applicant, Mass Gaming and Entertainment, suitable for licensure, subject to the conditions discussed. I know that Mr. Donnelly is here and his team, and he has some remarks, but of course I'm happy to try to answer any questions that the Commission may have.
Can I just ask a question? First of all, any Any questions?
I just had one quick question, and it's more of a process. Any ongoing or gaming violations that occur in other jurisdictions after the date of the suitability report are automatically or required to be filed with the IEP?
We do have a requirement, I'm not sure if it's a strict regulatory requirement, but we do view notification of all violations as part of the ongoing suitability for all of the applicants and licensees.
Thank you.
Other questions before we turn to Mr. Donnelly, which we will in a second? I had one question, and this is just, at the moment, picking up on the last piece of the financial structure. As I understand from reading the report and listening to you, that the essence of the position is that all the financing pieces are not in place, which is not unusual at this stage. But when the IAB looks at the equity that's pledged and the equity and the net worth of the pledgers, and looks at the credit facility that's available to be drawn on, and looks at the difference between the equity and the credit facility and the amount required to fund the project, the IEB has a high degree of confidence in the financial suitability of the applicant to execute this project. Is that a fair summary?
Yes, it is.
Okay. Okay. Mr. Donnelly, would you like to make any comments at this point?
I would. I will be brief, and I want to do a couple things. One, happy to be back. Was here in July, almost 2 years ago, and we were my client's proud of being the first entity and group of people found suitable in Massachusetts, and we've touted that some other places. So we hope that we continue that process. We're gratified by the report that has come out. And we're very excited about the Brockton project, and happy as could be with our partnership with Mr. Carney. So I'm representing Mass Gaming and Entertainment, but I also represent the Bloom interests in a number of states. So I wanted to put that on the record. Number two, staff has been terrific. I've said that before. I say it in other jurisdictions. Everyone was jammed up with a lot of work, and everybody on that side's been terrific to deal with. They put a lot of heavy demands on us, but not unreasonable, fair, flexible. So you all should be proud of that staff, and I say that to other people. It's a great staff you have. Now, why are we here today? Well, we're here for an update from what happened 2 years ago, and the test is, as you all know, but for the public out there, the test is real simple. It's good character, honesty, and integrity. That's what an applicant has to prove in all of these jurisdictions. And the group that controls MG&E, which is essentially a Bloom-related entities and persons and trusts that are created for the benefit of Neil Bloom's kids and grandchildren, have been found suitable, first in Mass in July a couple years ago. They've been found suitable in Pennsylvania, Ontario, Mississippi, currently pending in New York. The related Bloom entities regulated by the Securities and Exchange Commission as well. So we've been through this routine many, many times, and I think the general public doesn't know what gaming commissions such as yourself do. And it's worth a couple minutes just to say that it is extremely, and I say this sounds like a negative word, but it's a positive for what goes on. It's an extremely intrusive process, a process that is unprecedented in any other industry. People go through bank accounts, they go through net worth statements, they go through trust documents, they go through birth certificates, educational records, so that there is really no privacy that's available to the applicants that general public enjoys and would expect. And by the time that we come before a body such as this and hear a report like this, there has been a full, comprehensive, in-depth examination as to everything that goes on in these persons and entities' lives, including not only the good character side of it, but the reputation side too, which is the kind of stuff the book years ago about everything I learned in kindergarten are the rules. It's what other people think. And the Bloom entities and Bloom and the people associated with them and their reputation as business people, beyond the good character, that there's no criminal records, no civil record, there's no wrongdoing, but the reputation is very high too. It's not an entity that engages in sharp business practices. It's not an entity that you hear on the street, oh, those no good SOBs, they've been successful, but they're no good. You don't hear that about this entity. And I'm happy to work with them. It makes my job easy. We laugh down in Lang Say that how else could people like me make a buck with thank God for the casinos. But this is a good entity to operate with. It's an entity, I think, and the people that are associated with, you're going to be proud to have in Massachusetts if we're selected in the RFA 2 process. We feel the same way about Mr. Carney, same thing. We didn't know Mr. Carney. We're like anybody else in this room. You ask, what about George Carney? And we get the same report back. Good guy, successful guy, not a crisp dealer, a guy who you can trust. So we're happy with that reputation as well. I won't go on much further. We're very happy with the report. I think the report speaks for itself. That we have my entity and the Massachusetts and the Bloom Group and the trusts that are all created, all do possess the criteria under the statute, and I think have been demonstrated by clear and convincing evidence. The financing is there. Neil Bloom and his group have a reputation for that too, as I'm sure this board knows, but maybe the public doesn't know. In the financial crisis, the reason that Neil Bloom has 2 casinos in Pennsylvania is that during the financial crisis, the Pittsburgh casino, which was under development by another man, a well-known casino exec by the name of Don Barden, who since passed away, got in financial difficulties, as did everybody else in the country. And Neil Bloom was able to come in and save that project from bankruptcy because of the strength of his financial background. So I don't think there need to be any concern on that side of the ledger, and there's certainly no concern on the integrity side of the ledger. So with that, I'll be quiet, and I will be ready for questions, and we appreciate you inviting us here. I was remiss in not introducing who's with me here. To my immediate right is Paul Seaman, who is an attorney with LAM. As the director pointed out, LAM is an acronym for Neil Bloom's children, Leslie, Andrew, and Meredith. And Paul works for LAM and sometimes advises Rush. Also, Mike Marizio here, who is a long-term attorney for George Carney and for the Sweeney Group that they've put together, and he's been working very closely with the director, resolving and putting together the paperwork for an entity that's been in existence for close to 100 years, and we laughed, we had to go out and dig up some records out of the graveyard and so on. But so we're, again, happy to have Mike here, happy to have Paul here, and we're prepared to answer any questions commissioners may have. Thank you.
All right, thank you very much, Mr. Donnelly. Questions for Mr. Donnelly or for either of his colleagues who are here today?
Mr. Donnelly, I had a few questions about some of these violations and fines that have occurred since, I won't go back because we dealt with the ones prior to 2013, but a couple present themselves, and we've now been through this a number of times and are very familiar with seeing routine violations, for example, underage minors who inadvertently are admitted. But some of these others, I had some questions about. The first one would be the 8-6-14 violation with the 12 slot machines below the required 85% minimum. Do you have more information about that? That's a long period of time and a pretty hefty fine involved with that.
Yeah, I do. Thank you, Commissioner. What happened there is there existed at that time period the ability or maybe disability of slot machine to have different pay tables on it by virtue of how you put some calibrate or push some buttons when the machine was open. That no longer exists, and it was should not have existed, but wasn't our doing, but it was possible for a slot technician to put the wrong percentages in there. That happened with 12 machines out of, I think there's 31 or 32 altogether. A slot technician, when they open the door, there's they call it an EEPROM, but it's just an electronic computer chip. And those particular slots, there was the ability to put the wrong, what they call pay table in. Wrong pay table was put in, and it was a minor reduction. It was like 84+ percentage instead of 85%. That was, no one knew that had happened. The state of Pennsylvania periodically audits the machines, and they came in a random audit and found that. We did not know that. And for almost virtually all the violations you see, we self-report. There's a strong culture of self-reporting when we find out something went wrong. Didn't know that had happened. When we found out it had happened, we owned up to it, acknowledged it, paid a fine, and speaking to some staff beforehand, stuff happens. And you can't, with 4,000 employees that the Bloom organization has, you can't be perfect. What you can do is have a culture that is against that. You can have internal controls, and you can have investigations and discipline when appropriate. We did all those things. After the fact, they put in a procedure that now, in the future, there has to be a double check when that slot technician has, well, first of all, that, I say can't. That can't happen. That particular violation can't happen anymore because machines do not get on the table, on the floor, that have the ability for someone to make that mistake. But I will say that I've seen in my history people take the EEPROM out, the little chip, go into the back room and fail to check it. Not in the Bloom casinos, but I've seen it in New Jersey. So secondly, we have a system is in place that a supervisor has to double check that machine before it goes live. And that's in an internal control that is in effect now. So it should not happen again. As I understand it, it was only on a single coin betted, so it wasn't a large problem. The people, I'm sorry? Oh yeah, and Paul reminds me. The second control we're doing is quarterly audits now. That we check the machines ourselves to make sure that they're properly calibrated. So you can never say never, but that particular problem will not occur again, and we now have 2 safeguards in to protect it from happening that we didn't have before.
So the procedure was changed to make sure that should not happen again.
Double-breasted, two controls.
Okay. Some of the other violations I had a question about, you had a poker dealer ignoring the shuffler red lights on 2 occasions, and some other issues here that I think really hit on training issues. Underage, lots of times, right? That's security that needs to do a better job and pay attention to those issues. Certainly this incident with the dealer. You mentioned a lot of steps that you take in order to ensure things won't happen, but training was not one of them that you mentioned. I'm just wondering if some of these incidents do lead you to believe that courtroom paperwork, for example, that was improperly returned, count room rather, which is serious, right? That's a $50,000
That was
fine.
serious, I agree.
Yes. Is that someone just not doing their job, or they're not trained? You mentioned that you do investigations. What was the outcome there?
Yeah, you've got a couple of them. Let me talk about what we call blowing a red light.
Mm-hmm.
And what occurred was when you use a shuffle machine, that shuffle machine will put on a red light on the table, which indicates that either there's been a misshuffle or there's a card. It counts, actually, to count the cards, a miscard. The dealers in question on this failed to pay attention to that red light. They'd been trained, they knew it was a mistake, they knew they shouldn't do it, and they did it anyway. We had 2 clumps of incidents. The first clump of incidents was in the I'm stealing some of Paul's thunder because he's here, because he knows in greater detail if we have to, but if there's more detailed questions. But the first was on table games, and after those events occurred, everyone was retrained. Everyone had to do what we call a read and sign. You read that you shouldn't blow this red light, which is intuitive, and sign that in the future there will be 0 tolerance and will be terminated. And people did do that, but not in the poker room. And in the poker room, then we had these 2 violations. Same thing. There's 0 tolerance now, more reason signs, more training, and the employees who engaged in those problems were fired. We did an investigation. There was a firing of, in one case, a dealer, 1 supervisor, and I think a 2nd supervisor, and the other dealer was not fired because the supervisor had told that dealer to ignore the red light. He was fired, he or she, I forget. So, again, I can't say that someone won't watch that red light come on and say, I'm gonna deal anyway. If they do, they're gonna get fired, and they know it. And it wasn't an oversight, or it wasn't a lack of knowledge. They knew they shouldn't do that. As to the count room issue, yes, that count room issue, we're all perplexed by, because, by the way, there were, not only was that, were there people in the count room, there were regulators in the count room as well. And what would happen was, there's no loss of any money or anything like that, but if someone had written on what's called a fill slip, a slip that comes down the cage, and it didn't true out with other documentation, they would send that form back to the floor to have the floor correct it and make it correct. Absolutely, positively wrong. Like I said, there were people in there who observed it. The way that was captured is we had an external auditor come into the room and looked at it and said, what's going on here? We self-reported. We cleaned house with people who were doing that. And that will not happen again. I can't imagine that will happen again. The final thing you ask about, sometimes underage or other people coming in, I'm happy. Look, we're still not perfect, and we never will be happy, but we'll say a statistic that we're very proud of. At River, when we were last here, we had a number of problems at Rivers. As of yesterday, Rivers was at 611 days without an incident. Oh, so close to 2 years now. And they do it like when I was a kid, I worked in a steel mill, and they'd say how many days without an accident. They'd post it up there. They posted up how many days without an incident, and they're very proud of it. We'll occasionally get an event that will happen, but we're doing everything we can. So there is training. More importantly, there's a culture. Train, get the culture in, have the controls, and investigate and discipline if necessary. And we have those in place, and we're serious about it. We will be here as well.
Thank you, Mr.
Thank you.
All right, other questions? I had a couple of questions, I think probably directed best at Mr. Marizio. And this maybe is in RFA 2 land if when we get there, if and when we get there. But let me ask it now anyway, and that is that under the report, in the report there's an indication that the city of Brockton has a lease for a salt shed that's renewable at its option until October of 2016. And there's also the cell tower lease that's on this land as well. How does that impact the ability to develop the land.
First of all, good morning, Commissioners.
Morning.
And thank you
Morning.
for inviting us here today. Our current design calls for a very significant green zone or buffer zone along the back part of the Brockton Fair. This salt shed lease, which ends in 2016, and the cell tower is either in that green zone or just on the edge of it. And if it is on the edge of it, it would be in a parking lot area anyway. So it will have no effect on the ability to construct the casino or to open the casino. The cell tower I'd also mentioned, we have the right as the landlord, if we choose to move its location anywhere on the site at our cost. So if for some reason we felt it was necessary to do that, we would have the ability to move the cell tower as well.
All right, thank you. My second question has to do with the third condition that the IEB is recommending, which is maintenance, update and maintain a list of all the shareholders. Is there any reason why, given the history and the history of the organization and the importance of the upcoming vote, or the vote that would be necessary to actually consummate the sale, that the shareholder should not be notified by certified or registered mail of that meeting?
No, I think that's a good idea. We should document more than one way that we have contacted all of the shareholders, and we'd be pleased to do that. We've always held, my firm has been counsel to the Brockton Agricultural Society for close to 60 years.
6-0?
6-0.
You haven't been counsel for that whole
I
time.
haven't been, no. But our late senior partner, Joel Kozol, was, and his father before him. And so throughout that entire period, we have always had annual shareholders meetings. Our firm has been there. We've been part of the notification process. There's always been notice published in the Brockton Enterprise. It's been a stable and consistent method of notification to shareholders. So adding, direct mailing by certified mail, as well as the notice in the local newspaper, will be followed, and we'll certainly provide that information to IEB.
Mr. Maurizio, just roughly how many shareholders are currently?
I would say approximately 80.
Okay.
All right, thank you very much. I had one other question now, but I'm going to ask that question of Director Lilios, and it goes back to what Commissioner Zuniga was talking about in the first of those conditions. What if that condition were changed to say at the end that the society was required to provide documentation to the IEB promptly after the transaction occurs? The concern that Commissioner Zuniga raised was implicit approval of a transaction rather than reviewing it afterwards and being informed of it. We might then want to the IEB might want to recommend some action be taken afterwards, but would not be in a position of having to watch all these things and approve or disapprove.
I think that captures the essence of what the IEB should be doing, so
All right.
I think that's
All right.
great.
Okay. All right. Any other things that you would like to say, Director Lilios, after hearing Mr. Donnelly and Mr. Maurizio's comments?
No, just to thank them again for the process and to thank the commission as well.
All right. Well, I think that the report, you're to be congratulated, and the staff is to be congratulated. This is really a very thorough and readable report. It clearly reflects a great deal of probing and updating the information that we had before. It's easy to follow. It's succinct. It's well done, and obviously reflects a great deal of cooperation from the applicant as well to provide this information. It is an intrusive process, as Mr. Donnelly suggested, didn't suggest, he said. And it is, I think, unparalleled in any other industry. But the ability to do this, the ability to do it in a timely fashion, depends not only on the energy of the investigators and your team, but also on the cooperation of the applicants. So it's a combined effort that brings us to this point. Any further comments by commissioners? Otherwise, it seems to me it's time to think about framing a motion with respect to the task, the issue that's before us, and that is whether the applicant has shown by clear and convincing evidence, and whether we're persuaded that it's shown by clear and convincing evidence that it is suitable to hold a Category 1 casino license in Massachusetts. Any other comments?
No, just the same comments to thank both the applicant and the applicants, or the applicant with its number of qualifiers, and the IEB for the work that they've done. Really good work.
Okay, it seems to me that we need to, as we did before, to find all of the entities, Rush Street Gaming, Mass Gaming and Entertainment, and Sweeney Investments, Inc., qualified as entities, and that we need to find that each of the individual qualifiers is qualified, and that we need to approve of the 4 conditions under which our vote is, on which our vote rests. So let me, if I might, try to frame a motion that encompasses all of those. So I move that the commission find that Mass Gaming and Entertainment, LLC, Rush Street Gaming, LLC, well, actually, it's more than the 3. Mass Gaming and Entertainment, LLC, Rush Gaming, LLC, Rush Street Gaming Partners, LLC, Mass Gaming Holdings, LLC, Sweeney Investments, LLC, 2013 AGB Family Dynasty Exempt Trust Number 2, 2013 LNB Family Trust Exempt Number 2, 2013 Meredith A. Bloom Wolf Family Trust Number 2, Neil Bloom, Andrew Bloom, Leslie Bloom, Meredith Bloom, Gregory Carlin, David Patton, Timothy Drenkoff, Joseph Shabetta, Suzanne Trout, Zaletta M. Wyatt, James J. Jabozinski, John Risley, George Carney, Letitia Carney, Carlin Dynasty Trust, have shown by clear and convincing evidence that they are qualified to hold a Category 1 casino license in Massachusetts, and that conclusion is conditioned on 4 principles. Number 1, all of the transactions involving the society, and that is the Brockton Fair Society, and Mr. George Carney, Ms. Letitia Carney, any of the Carney-affiliated entities, and any qualifier, including but not limited to the disposition of Lot 7, are required to be documented in detail, and the society is required to provide such documentation to the IEB promptly after the transaction occurs. 2, that the society's books are required to be maintained according to the generally accepted accounting principles. 3, that the society is required to promptly update the contact information for its shareholders, and to use the updated contact list to notify the shareholders of all meetings, including the notice to shareholders in advance of the vote for the sale of Lot 7 to Mass Gaming and Entertainment, which notice shall be served and delivered by certified or registered mail. And 4th, that the society is required to continue to maintain all of the required filings with the Secretary of the Commonwealth.
Second.
Discussion? All in favor?
Aye.
Aye. The ayes have it unanimously.
Thank you very much.
All right.
Thank you.
Thank you.
Look forward to
Thank you.
seeing you for the RFA too. Thank you.
Thank you.
Thank you.
And Commissioners, if I could make the reminder that since you have voted for suitability under 205 CMR 115.05 subsection 6, no notice has to be issued by the City of Brockton to the citizens with respect to the upcoming vote.
Correct.
All right, that is simply an observation and no votes required for that. I should add that suitability is, of course, a continuing process. It's been continuing for the past 2 years. It will continue into the future, and so comments from anybody as events materialize are always welcome, and suitability remains an open issue. Thank you all very much.
Thank you.
Thank you.
Thank you.
Thank you.
All right, we have one other item on the agenda. Item 4, we have a report from the Legal Division. And let's take that, do you want to take a break? This will only take us, I
No,
think,
we
a
can-
few minutes.
Yeah, we can keep going.
Yeah,
Let's do it.
right. All right, Mr. Grossman,
Good morning, Commissioners.
good morning.
Good morning.
We have before you 250 CMR 140, which you took a look at your last meeting. There were a number of adjustments that were recommended to the draft. You'll recall this section of the regulations has gone through a public hearing. You've previously approved the amended small business impact statement, and upon your approval, this regulation will be ready for enactment.
Okay, we did go through this at our last meeting. There were some changes. We requested that we take a look at those changes in writing. We basically approved them in principle. Here they are. Questions, comments?
Nope.
They track, as far as I can tell, they track precisely what we talked about the last time, but it's good to be able to review them in writing and in context and in front of us, so. Any questions of Mr. Grossman?
205 CMR 140 is included in the packet in its final version, as we discussed last time, to then become promulgated effective today, right? If we vote on it.
It wouldn't be effective today, but it would be effective in
two-
2 weeks from tomorrow.
2 weeks
in
from the
effect.
filing with the secretary.
Right.
So we would be approving both the small business impact statement and the regulations?
Oh, yes.
Yep.
Okay, sorry.
Any other comments, questions? All right, do I hear a motion?
Yeah, I will move that the commission approves the 205 CMR 140 gross gaming revenue tax remittance reporting regulations as presented here in the packet, as well as the amended small business impact statement for the same said regulations 205 CMR 140 as presented here today.
All right, is there a second for that motion?
Second.
Discussion? No discussion being heard, all in favor?
Aye.
The ayes have it unanimously. Now, as I began to say, albeit a little bit out of order, item number 4 on the agenda is being withdrawn. That's not quite ready for presentation today. We'll return to that at a future meeting. And therefore, unless there is something else we should do, I would entertain a motion to adjourn.
So moved?
Second?
Second.
All in favor?
Aye.
The ayes have it unanimously, and we are adjourned.